Welcome, everybody. Good to see you on a nice, chilly Canadian afternoon. Glad you could make it out. Very pleased to present our speaker for today, Professor Lorenzo Zucca, who's joining us from the Dickson Poon School of Law at King's College London. So very pleased to have you here, who graciously agreed to come on a January afternoon. So very glad that you could make it and be with us. Professor Zucca has degrees from graduate degrees from Oxford, as well as you've completed your PhD at the EUI, the European University Institute in Florence. His main research interest, Professor Zucca works on issues of constitutionalism, freedom of religion, Islamic terrorism, anti-terrorism policies in the EU, as well as philosophy of rights, especially in European and international contexts. He's published recently 2 books with Oxford University Press. The first one, Constitutional Dilemmas, Conflicts of Fundamental Legal Rights in Europe and the USA. It was published in 2007. And more recently, in 2012, A Secular Europe, Law and Religion in the European Constitutional Landscape. And so today's paper will be sort of a continuation or extension and exploration of some new ideas on freedom of religion and secularism in a European context. So its title is Rethinking Secularism in Europe. So very pleased to have you with us today, Professor Zucca.
Thank you very much. I'm really very grateful to you, Michael, and Francois for hosting me in Canada. I'm very happy to be able to present something that's it's really a rough draft and something that I'm thinking about, even if I worked on these issues for a certain time. But we are going through a difficult period in Europe, and it is a very daunting and difficult age in which we live, both in terms of ability to open up to diversity and in terms of coping with the challenges that religion brings in the public sphere. I would say that we're far away from being there. Perhaps Canada can provide some lessons in how to be a more inclusive community. Certainly Europe at the moment, in all its states, is not very inclusive at all. So the topic for today is rethinking secularism in Europe, because I do think that part of the problem in Europe are related to the way in which we think about secularism and the way in which secularism features in judicial decisions, both at the national level and at the supranational level. And here is the link with the transnational somehow type of litigation. I think that religion is something that's is not often talked about in relation to transnational law, but there is nothing more transnational than religion after all. And religious law is by definition a transnational law. So I hope that it's not too disappointing. Now, the starting point of my reflections today are very emotional and very topical. It is something that I decided to do in response to the several terrorist attacks in France. And I have special links, personal links with France, in the sense that part of my family lives in France and I lived in France for a while. So I'm struggling with trying to explain or understand what is wrong in France and what is it that explains the situation in France, the present predicament. Obviously, you're all aware of the Charlie Hebdo tragedy and the Bataclan tragedies. Something that's I try to uncover is whether or not we can make sense of the way in which French minorities, French who are born in France, decide to reject the motherland and in fact, find it even more exciting to go to Syria to join ISIS rather than defend the Republican values. So that's the background and the motivation for such a perspective. I often tend to have a Marxist reading of the reasons lying beneath the disintegration of France. So most people, when talking about Charlie Hebdo or Bataclan, they say, well, it's a matter of religious extremism, it's Islam, knocking at our door, and it's the other coming from the outside. But of course, my Marxist immediate reaction is that, very much it is due to the alienation that France has produced over the years. Alienation that begins in the banlieue, in the suburb, in the French suburbs, and then alienation that somehow ends up in all kind of social settings. Originally, if you look at the people who are engaged in these terrorist attacks, both the Charlie Hebdo or Bataclan, they're not coming from religious families. They are somehow isolated individuals that become radicalized in prison or in other social settings afterwards, after they understood that France will never integrate them. This is part of the picture, though. So economic alienation explains part of the underlying story. But of course, many retort that it's not the whole story, because it's not only economically disadvantaged people. It's not only an issue of coming from a poor background and becoming radicalized. And I do not deny this at all. There is a sense in which there is political alienation in France and in Europe, of course. And political alienation runs possibly as deep as economic alienation. And it is chiefly due to the fact that France or Europe, and I do think that there is a parallel between France and Europe. The European project, the EU project, has been molded and created as a mirror image of a grand France. They are both incapable of generating deep positive emotions or a deep feeling of allegiance towards the political entity. So in both ways, there are this alienation also touches people who are not necessarily poor. In London, we have students at King's that have been radicalized. So they come from a relatively wealthy background, and yet they end up joining ISIS in Syria. So I'm not talking about something abstract. I'm talking about students that we have been in touch with. The other fundamental problem that I see in Europe throughout different states and in the case law of national and international courts is the fundamental problem of the double standard. And this, to me, is a very, very important issue in the sense that I really believe that if you read closely the case law of the European Court of Human Rights, what you will discover is that in the last 25 years or so, when the European Court of Human Rights started adjudicating on freedom of religion, this jurisprudence has tended to show a deep bias towards Muslim and a preference towards Christian symbols, clothing, and practices in general. So I could give details about it, but it's not really the point here. And even if I'm not the only one in advocating this, another example of this thesis could be found in Sam Moyne's work on the history of human rights, in particular his work on Christian human rights, presenting the European human rights ideology as rooted in Christian ideology, and as a consequence naturally opposed or naturally discriminating towards non-Christian minorities. I think that we have an overlapping idea here. I do think that the ECHR displays a bias that is not explicit, but it's certainly an implicit bias that runs throughout. And in my paper, the example I use are two examples of two landmark cases. On the one hand, the crucifix in the classroom case, which is a case originating in Italy. And it is a very simple case. It deals with the presence of the crucifix in state schools in Italy. It is to this day still hanging on classrooms' walls, even though Italy is a constitutional, well, a secular constitutional country. So some Italian plaintiffs decided to go all the way to Strasbourg to complain about the presence of the crucifix as being incompatible with their own convictions. What is interesting is that in Strasbourg, at the first stage, the courts decided to side with the plaintiffs and recognize that Italy was violating the rights to educate children in a way that is compatible with parents' convictions, that is free from religion. But the decision at the first instance created a very deep backlash, so much so that a transnational alliance of Christian forces came together to plead in Strasbourg in favor of the power of Italy to decide which symbols would represent its own identity. The transnational alliance I'm talking about covers Orthodox Russia and all the Orthodox countries that were defended in Strasbourg, were present in Strasbourg as third-party interveners. Professor Weiler of NYU actually intervened on behalf of Russia, Moldova, Malta, Bulgaria, and other Orthodox or peripheral Christian countries. The Vatican obviously intervened in Strasbourg to defend its own rights to tell Italy what to do, and the U.S. Protestant associations filed 1,000 amicus brief in Strasbourg, all claiming, well, all siding on the same side, that is against the Italian plaintiffs that were on the side of secularism. So, you know, this is a story that you don't get to see from outside. It's something that you get to see if you look behind the doors, and it's something that it's quite a powerful story about the presence of Christianity and religion in adjudication, in legal settings, how much the Christian lobby is prepared to do in order to defend certain symbols. Obviously, when I said this last week in London, we had a debate with Sam Moyne and John Finnis. John Finnis told me that I was dreaming, that this is just a small case, it's not a very important case, it's just a symbol. After all, you know, the crucifix, it's not very aggressive. It's not. It's a cultural symbol. That's what he told me, and that's what the Catholic Church says. It's official Catholic doctrine. So yeah, but yeah, that's exactly what I thought. You know, hey, well, but that's the Passion of the Christ. I mean, it's something so neutral and well. anyhow, so for them, I am dreaming. I am sort of dreaming all this story, and there is no bias whatsoever to be seen. So, you know, you may think that all this is fairly uncontroversial. It's very controversial in Europe. It's very, you know, what I'm saying is anathema for many, many people. So the question I'm still interested in is, well, how should you know, European states and the European Court of Human Rights, European institutions in general, address the religious question, the problem of religion being a much more vocal and present group in Europe. So the way in which my paper is organized is by distinguishing what I call negative secularism and positive secularism. So the first part of the paper attempts to give a diagnosis of the problem. So what's wrong with the present state of things, and why is France or the European Court of Human Rights position wrong? And when I say negative, I mean two different things. So the first most obvious meaning of negative is that it's secularism molded in opposition to religion. So it's a form of secularism that has been shaped and is deeply dependent as a consequence on the definition of religion. So in Europe, it's obviously a very Christian-centered conception of religion, and as a consequence, it's a very Christian-centered conception of secularism. So there is a deep interplay between religion and its denial, and to a great extent, the existence of Christianism and its denial is not as sharp as we would want to put it. I guess Europe, is here now because there are so many ways in which a confusion between religion and secularism have shaped the political and the social background. But the second meaning of negative secularism is deeper, I think, and this is part of the deeper methodological aspect of my paper. I think that's what secularism is incapable to do, laicite or secularism, however you want to call it, is to engender, create deep political emotions of belonging and attachment to one society. So, to take the example of France, France is incapable to engender a positive belonging and to convince people who are not immediate part of the French society to join the society and the values it stands for. Now, the sort of French revolutionary tradition, to put it in a different way, has run out of steam, and it doesn't seem as if France is capable of telling a new story about what it is to be French and why it would be so crucial to be Republican and secular nowadays in France. So it's this kind of sense of negative that is of interest to me beside the other one that is more conventional. What happened in Strasbourg at the level of the Council of Europe is that judges of the European Court of Human Rights have tried to negotiate the problem of secularism by denying its importance or by downplaying its importance. So in the crucifix in the classroom case, quite a few judges expressed the view that secularism, the position defended by some of the plaintiffs, is just another private conviction. So, you can be a secular parent, or you can be a religious parent. Both of you are on the same plane, and the point is not to respect a secular environment where everyone can have a role to play. No, it's rather to negotiate or to balance the conflicts between secular people and religious people. And I think that this was a big mistake on the part of a lot of judges in Strasbourg to present secularism as a private conviction rather than as an underlying political doctrine. But the other points that emerged in Strasbourg and at the level of the EU is that quite a few officials defended the idea that in any case Europe should be interpreted, the constitutional identity of Europe should be interpreted in the light of Judeo-Christian values, as we were saying before. I do not quite understand what Judeo-Christian values really means, if not, as we were saying before at lunch, non-Muslim Europe. So it's not a positive understanding of European identity, it's rather a negation, once again, of the fact that Europe's population now is increasingly more varied and pluralist, and it's way beyond the Judeo-Christian Europe that some people would want to defend. The next problem or the next element of negative secularism is that a lot of these decisions in Strasbourg and in France downgraded secularism as a mere ideology. And as I say in the paper, to be honest, part of the blame should be at the door, should be rested at the door of secularism itself. The defender of secularism lets secularism become an ideological doctrine that is mainly in the business of putting religion or restraining religion in the private sphere. And this reading of laïcité or secularism comes straight from the French law, the Loi de 1905, the statute that introduces secularism in France. This statute is simply introducing a legal principle of separation between church and state, the Catholic Church and the Republican states. I just, at that point, in historical time, France was trying to establish its secular and Republican pedigree. So the conflict, the bitter conflict with the Catholic Church was something that was justified amply, this type of legislation, which, as I said, was simply a legal document that tried to distinguish the realm of the state from the realm of the church. However, this statute got interpreted in many different ideological ways. A brilliant French sociologist, Olivier Roy, wrote about it in a book on French secularism and Islam, and showed that the French society interpreted this piece of legislation as dictating a clear, a clear ideological principle according to which religion should be confined in private, meaning that as long as you're within your private walls, religion is barely acceptable, and as soon as you step out, a religion becomes unacceptable. And this kind of interpretation is at the foundation of the legislation on the hijab first, and then the burqa in the last few years. It's the idea that the burqa cannot be an item on French public streets, which, by the way, creates a very strange understanding of what is private and what is public, because in my understanding, walking down the street with whatever dress you have is still an act of private behavior. It's not a public behavior. But that's the way in which French legislator and courts interpreted it. So obviously, what is important to underline here is that the context, the French context, shaped the understanding of secularism in so many ways that nowadays laïcité is actually working as a tool or instrument to single out parts of the society that are not belonging or are not recognized as being part of French society and are discriminated as a result of that. And this results in what I was pointing out before as secularism as a form of Islamophobia. So now France is not the only state. In Europe, there are endless cases. You can mention the minaret case in Switzerland. You can mention the hijab legal cases in France. You can mention Sharia law in the UK, and so on and so forth. There are endless examples all over Europe of sheer hysteria towards whatever belongs to Islamic practices. An example is particularly telling when the Archbishop of Canterbury gave a lecture at the High Court in London on religion and legal pluralism. He addressed the barristers on the issue of arbitration, religious arbitration in the UK, saying that in the UK you can have some aspects of private law dealt with by religious courts, such as the Beth Din for Jewish law, and there are some Islamic councils practicing Sharia law. So he wasn't defending this practice. He was just describing English legal practice. So that's the way it works still nowadays. But the audience and the media singled him out as one of the defender of Islamic values, and soon after that he had to resign because of the mediatic pressure that was put on him. And I repeat, he was not defending these practices, was just describing it. But perhaps the most important example of all this is the so-called SAS case, which is the burqa case. The burqa legislation is something I mentioned before. It is legislation that bans the wearing of burqa in public. Now, what is interesting is that I think this piece of legislation is the sheer result of populism. There is no real, serious policy reason to present this legislation. Sociological studies have demonstrated that there are 2,000 women in France wearing burqas. So what they did is they interviewed each one of these women in order to see if the rationale of the legislation was correct, namely that burqa, anti-burqa law is meant to protect women. Well, what the study produced is very interesting, namely that most women, out of these 2,000, most women who wear burqa are women that are not married, are not linked with a family, so they do not have a direct pressure from their husbands or brothers. They are doing this because they want to create a new narrative of their life, in the sense that some of these women are prostitutes who are reconstructing their identity. Some of these women have been divorced, and so they want to present themselves as particularly pious women in the Muslim community. So, you know, the story the actual sociological story tells a completely different narrative than what French institutions would want us to believe. But what is more striking and incredible is the fact that France used, the government used this argument, the argument of living together, as an argument to prohibit the burqas. So what they argued was that the fact of wearing the burqa was creating an impossibility to communicate with people, and was undermining the principle of living together in the community. The European Court of Human Rights accepted this argument, out of all arguments, as the most important argument to ban and to respect the ban of the burqa as compatible with the European human rights. I think that, this is a highly contentious way to justify the ban of burqa. If anything, living together should include a very large and generous respect of minority lives. But this is not very much, this is not at all the way in which France decided to go. So negative secularism includes all these different elements, and it is something that, I think is amply demonstrated in practice. But as I told you before, this very description is contentious amongst many people. But what's is important in my account is that at bottom, negative secularism is the symptom of a very empty political space that is incapable nowadays to promote positive political values of belonging, and in particular is incapable of creating a positive political emotion that brings people together in a place that they want to share. This is something interesting, because a lot of people presented the need of the fact that a lot of French young people emigrate to Syria in order to fight with ISIS as a sheer teenager type of search for a joyful experience. That is, being part of ISIS would be a more joyful experience than remaining as a citizen in France. So obviously this is what prompts me, or prompts my need to rethink secularism in Europe, and what I want to defend in a more positive type of secularism. Obviously, by positive secularism, I mean a secularism that is not tightly defined in opposition to religion. So secularism is a much broader political position, in fact, I would say ethical position, that is inspired by the need to defend diversity of all stripes, of non-religious and non-religious stripes, and to a very great extent, I would say that there is an overlap with Charles Taylor idea of political secularism. Although the most interesting part is where the two accounts take part. So I would say that Charles Taylor's political secularism is still too much indebted to Rawls' idea of overlapping consensus, and is relying on the hope of bringing together reasonable people with the intent of defending a principle of neutrality that I do not think is viable in Europe, precisely because of the reason that I have given before. There is a very little space for bringing together reasonable people without attacking first the overwhelming bias that is characteristic of European positions nowadays. So the first stage of my ethical secularism would involve a very direct work on the psychological underpinning of political culture that is systematically targeting non-Judeo-Christian people at the moment. So, in other words, I do not think that neutrality is a viable antidote or response to the problems that religious groups and religious practices are raising in Europe or anywhere in the world, I would say. But in Europe in particular, in the European context, that is very, very, very problematic. And here the comparison with Canada perhaps is interesting in the sense that, as far as I do understand, Canada, is way ahead in this game. Europe comes from, Italy, where I come from, but most other states come from a very homogeneous, an idea of constitutional identity that is deeply homogeneous. And even if it doesn't embrace the establishment in the Constitution, it's de facto ends up establishing one religion in the constitutional practices. And it's true in Italy, in Greece, in Spain, and most of Southern Europe, but also in Northern Europe. So, neutrality, I don't believe that neutrality is capable of negotiating the secular dilemmas that are arising because of the return of religion in the public sphere. And I do not think that, philosophically speaking, we can helpfully refer to an overlapping consensus on reasonable people, because I think that wherever you go, be it Italy, France, or Spain, it is at the moment impossible to conceive the possibility of converging towards a new redefinition of positive secularism. In other words, we are completely stuck with a negative attitude towards religion, but in particular a negative attitude towards new religious minorities. And the second problem with that I find with Taylor's approach has to do with the role of conscience, in particular in its book with McClure, that tries to move away from freedom of religion and towards a much more individualistic conception of freedom of conscience. And I think that that is, in fact, a very culturally specific move. I would say a very Protestant move that tends to put conscience as the core of the religious practice, which is not true in most other countries that I know in Europe, because religious practice does not boil down to conscience. In fact, in Catholic countries, conscience has never played a central role in understanding of religion, because conscience is necessarily faulty in the Catholic tradition and cannot be used as a way of identifying core religious positions. And another reason is that it does promote words of conscience. So just to come to the conclusive part of the talk, what I am proposing instead is something I call positive ethical secularism, which is not a political, it's crucially not a political doctrine, it's a comprehensive view of the world, in the sense that I really believe that secularism is a comprehensive view that should promote diversity, and the state should be instrumental to promoting diversity as a value superior over homogeneity. And this is something that, well, is very crucial to understand in Europe, where the default position is still a preference for unity and homogeneity. So my account is necessarily, well, is a two-step account, in the sense that I believe that a realist set of instruments are necessary in order to get to a normatively more desirable secular position, an idealist account. So it does necessarily go through these steps, and the first instrumental stage is necessarily prior to the second idealist stage. So, as I said, positive ethical secularism is a comprehensive view, and it crucially argues that the diversity of religious and non-religious views is to be protected as superior over any case of homogeneity. So, in other words, if you take the crucifix case, it's a false dichotomy to think, well, it's either a classroom with or without a crucifix. I think that obviously the first step would be to remove the bias, that is, to take the crucifix away, but then the diversity is not necessarily fostered by the blank wall. It would involve a deep rethinking of what a pluralist classroom really looks like. So it is a much more substantive idea of secularism, and requires a much deeper intervention on the part of, well, on the state in collaboration with the people on the ground. So in this sense, well, it is a positive political project, yes, because it attempts to take Europe from its homogeneous default to a state of diversity, but it also attempts to reignite the debate on European political values, or what it is to be European, not simply in a way that is engaged in neutrality, or in a way that does not promote a completely new understanding of Europe as a place that can engender positive political emotions. And the illustration of this is precisely the example I took before. The crucifix in the classroom is particularly interesting because, well, I think that it is a default of imagination to say that the classroom should simply be a blank or a sort of neutral classroom. I think that each classroom should be given a very ample room of maneuver to reimagine its diversity at the local level, in collaboration with with the parents, the family, and the point would be to transform the state classroom into a real experience or a real laboratory of tolerance, which in Italy is not the case yet. Only Christian feasts are celebrated, and not only Christian symbols are accepted and promoted. So the realist or instrumental part of my paper relies on the idea that the European Court of Human Rights and European states can and should promote the existence of a marketplace of religions. That is a marketplace of different religious practices, and the first point is to remove the barriers of access to religious practices. So new religions that appear in Europe now are trying to get into the marketplace without success. It took non-Christian, non-Abrahamic religions a very long time, if at all, to be recognized as religions in European states. And the second point of the marketplace of religion is that it should foster a membership that comes with equal burdens and benefits. And this point is to say that the idea of a separation between church and state is something that should be put aside as an unhelpful metaphor. The state collaborates with the churches and religious practices in many different ways, and it is possible to award benefits when religion is advancing the cause, and take away from it if it doesn't. So as a very last conclusion, the role of the European Court of Human Rights is unfortunately very central, and yet the European Court of Human Rights is completely underprepared to cope with these kind of challenges, in the sense that at best it is open to transnational religious lobbying that is pushing the European Court in a very precise direction. We are, unfortunately, in the hands of the European Court of Human Rights precisely because of transnational or transatlantic influences. Europe is simply mimicking the US in bringing to courts more and more freedom of religion cases and let them be influenced by an increasing number of transnational, transatlantic NGOs. So the challenge for Europe is huge, and the challenge is, in fact, of positive ethical secularism, to first of all get rid of the populism that is intrinsic in European legislation, and then in a perfectionist type of understanding, to ask from the states and the European institution to nudge the practices of Europe towards a sense of diversity that is characteristically not present at the moment. And with this, I just conclude. Thank you.
Okay, thank you very much, Professor Zucca. So we will now open up for questions. You'll notice there are a couple of microphones that are placed. These aren't to amplify the sound in any way, but simply to record it for our video. So please wait for a microphone to ask your question. Yeah. Okay. Xavier.
So thanks so much. That was fantastic, and it broadly speaking, I think that you and I are on the similar page to where we'd like to see secularism go. My first question was between American and European models of secularism. In America, we seem to have seen a lot of the same sorts of populism that you were worried about taking place in Europe. So Donald Trump, one of the major political contenders, thinks that there should be a national database on all the Muslims in the country, which is a particularly scary thing, I think, for most of us here. But one thing that America has is that freedom of religious expression just has such a pride of place in the American Constitution that a lot of the populist attacks against Muslims had to be privatized because the courts or the democratic institutions were unable to translate their prejudices into laws in the same sort of way. The other side, so when I'm having the same sort of argument that we need to rethink secularism with people that I know, one of the points that's frequently brought up is in the American system, for example, there have been a number of states that have tried to pass laws that guarantee freedom of religious expression. But the particular form that these laws have taken have been stores should be allowed to discriminate against homosexual couples. That's been the big one. In particular, in Arizona, they tried to pass a law, and there have been a number of different cases. So how do you respond to trying to fight for religious diversity while at the same time not opening up space for religious people to use religion as a sort of trump card that makes it so that people can't, so that they're able to discriminate against others in ways that also go against our sort of human rights convictions?
Thank you.
Sorry, that's a long question.
No, it's a brilliant question. And it's very important as far as present concerns are advanced. I would say that it is a tension that exists very much in Europe and in America too. There are numerous examples of cases of people trying to put forward their religious convictions and say, well, there we are, I am not going to register homosexual marriages because I don't believe this is the case, and so on and so forth. So the way I respond to these cases of alleged objection of conscience is by pointing out that there is I do not think there is a moral right to conscientious objection as far as religion is concerned. It is at best an issue that allows for prudential accommodations. So an important case in the UK that went all the way to the European Court of Human Rights dealt precisely with this issue. An officer of London Islington Borough was dismissed because she engaged in discrimination. I think that the ultimate decision was procedurally flawed, but substantively correct. So the court decided that she had no right to be reinstalled, but I do think that the only thing that we can say on behalf of religious people is that they have a right to be treated fairly, but no right to use their conscience in order to be exempted from practices in this case. In particular, when there is a clear harm that can be evidenced, as in this case.
Queue, Dan, you're next.
Hi, Lorenzo. So I'm going to defend negative secularism, or a revised negative secularism, because I think you presented a somewhat I mean, I don't know of anyone who would subscribe to what you call negative secularism. But so I will begin by saying that what you defended, I would not call it secularism at all. You want diversity, which is a totally separate thing, and it may be a good thing or it may be a bad thing. But secularism is committed to the idea of that secularism, that there is value in being secular and there is disvalue in religion, and that's or at least disvalue in particular context. So now I don't want to fight over terminology, but for me the idea of secularism is that there's value in secular life over non-secular life, and it could tell also a story about all sorts of bad things that religions have brought to us, but that's in a way a bit of a side matter. What I would so I'll ask you two questions. So you say, well, we need to rethink or to value diversity, and so one question is why. Now, there is work by economist or political scientist called Scott Page that says that places that value or promote diversity perform better, and companies, more diverse companies perform better than less diverse companies. More diverse societies perform better, and if that's the case, then that's a good argument for diversity. But I've not heard anything from you about why diversity is valuable. That's in terms of the question. And nowadays we live in an age in which, of course, diversity is a great thing, and we like the fact that we can eat in different restaurants and lots of cuisines, and we like that, and that's great, and we think that but in terms of a political argument, I would want to hear more. Now, and in terms of the concern for, or the argument for, if you want, a form of negative secularism, it would go something like this, I think. The basic assumption of ideas about law is that it applies generally to people, and of course we always recognize that not all laws apply to everyone. There are laws that apply only to old people. There are laws that apply only to pregnant women. There are laws and so on, and that's fine. But for people to get this sort of exemption, they need to bring an argument as to why they should be exempted from the general rules. And the argument is that religion is not a valid argument. And I know I take an extreme view on this, but that's my view. Religion cannot bring a valid argument for exempting itself from the general laws. And because of that, there is a difference between claims to exemption from general rules for pregnant women, for old people, and so on, from the claims of religion. And in this respect, and if I may add one last thing, it's sort of in relation to your comment, actually. So the problem is, those who want to accommodate religion say, oh, I want to accommodate religion until I don't like the way that they do. And they try to say, oh, I want to accommodate them on some things, on dress. I don't want to accommodate them when they discriminate against. So, and I would say, no. I would say there's no principal distinction between the two. And the only way you can defend a position by basically saying, or either accommodate everything, and then you have to accommodate the person who wants to discriminate against homosexuals because of religious conviction, or you say, bring me a non-religious argument, which means you don't accommodate anything. So that was, I don't know if it was a question, it was more kind of, that was my attempt at defending the negative, I think a a more defensible version of negative secularism, and I wonder what you make of it.
Great. Well, thank you. I mean, it's a great set of questions, and I guess it's quite a lot in the sense that, in particular in France, people say there is no distinction. No? It's that. It's secularism, laicity, and there is no reason to distinguish. So we have to stick to our guns and not allow to be bullied in a different direction. So it is my job to make the distinction meaningful. And the value that I appeal to is indeed the value of diversity. And you're right to point out that in my presentation, I have not developed something that is in the paper. That is the reason why it is important to value diversity. First and foremost, diversity of thought. So this is, in fact, interestingly enough, a crucial element of what Jonathan Israel has identified as radical secularism, and as opposed to radical enlightenment. Sorry, you're right. But I draw a parallel between, or a link between radical enlightenment and radical way of radical secularism. And if anything, what I am defending is precisely, if you want another neighbor, radical secularism. So a secularism that is committed to getting rid of the homogeneous thinking that was typical of a Christian commonwealth that had a very precise set of values according to which you would either be right or wrong. And what radical secularism or radical enlightenment is up against is precisely the stifling narrowing of diversity of thoughts. And it's that kind of diversity, first and foremost, that I defend in my paper, the diversity of thought as, well, the diversity of any thought experiment and experience over and above any other experience. But, well, religious beliefs would be a subset of thought. So, if anything, I protect religions in the name of the diversity of thought rather than as a protection of conscience. And this actually leads me to the second point you were making. Well, the third point. I don't think that we are very different on exemptions. In fact, if anything, I'm very skeptical too to whatever amounts to accommodation of or exemption of religious practices. I'm very, very skeptical. You know, I do not think that religious exemptions should be extended or generously granted. On the contrary, I do think that there is a very big difference between granting exemptions. I do not allow them in my way of thinking, and protecting freedom of religion. This is something that is often confused in the sense that, well, there is a big space for freedom of religion when legislation has no right to intervene in regulating practices that are otherwise regulated. And you know, wearing the burqa is, or religious symbols is one of those practices. So it's not about a matter of accommodating, it's a matter of protecting freedom of religion. The other matter, well, the exemption from valid laws is different, and I think that we agree on that, you know.
I think so. So in this respect, I think we agree. I mean, I may not like women wearing burqa, but I think it's none of my business how people dress and whether I like it or not. And so in this respect, but so you want to defend freedom of religious thought, but then aren't you reestablishing the distinction between the public and private that you wanted to denounce?
Right. Freedom of religious thought is supposed to be absolute, in the sense that I do not want to curtail or constrain in any matter whatsoever religious beliefs. If someone wants to hold religious beliefs or non-religious beliefs of whatever kind, that's their absolute right and freedom. Well, of course, when we move from the realm of thought and belief to the realm of action, and conscience is the bridge between belief and action, then that's where I start positing a series of limits. Legal limits in particular, but I do not think that this means to simply defending religious in private. I mean, I'm happy with religious people bringing religious practices in the public sphere, as long as they are compatible with the official laws. And if they are incompatible, then we have to adjudicate. Again, the example of the burqa, I think that the burqa legislation is wrong. So there is an incompatibility between legislation and religious practices, but what is wrong here is the legislation, not the practices. But, it can be the other way around, too.
Okay, just I'm a bit worried because there are some new faces that I'm going to miss anyone. So you'll see that I'm trying to find people who are giving me an indication. So you want to ask a question, just so that you want to be on the queue. Okay. Siggy, you're here next.
Well, maybe let's read your papers. Jewish and Islamic law and answer what is considered to be a contract, what is considered to be reasonable compensation. We have also provision with respect to property law, criminal.
What are you getting at in the last question?
Just your view about the idea of human rights, because the universality, you would actually defend any universality, any transnational value of human rights. Because to me, it seems to be fundamentally different. The case of Burqa, without clear infringement of vital integrity, as opposed to cases of discrimination using religious laws or cases that violate human integrity.
Okay, thank you. Yes, well, there are various different concerns in here, and at the beginning you asked about the difference between Christianity as opposed to other Abrahamic laws, religions that are definitely more regulated or codified, perhaps even. And I definitely grant the fact that there is a deep difference between the two, and obviously it does factually it does create a greater number of occasions for conflict between religious practices and ordinary laws. And in fact, this somehow is connected with Dan's point. There is an interesting example worth discussing, whether or not German law can prohibit the practice of male circumcision, So how do you look at it? Is it a private practice or is it a practice that involve somehow bodily mutilation and therefore is a practice of public interest? And is it the fact that German laws are expressing a hidden Islamophobia, but also anti-Semitism, or is it based on health issues that are objectively defensible? I think this is a really tricky case. It's a really interesting scenario, and it's just one of the possible scenarios that arise in virtue of the fact that there are so many more rules involved in certain practices. So Christianity, to put it in St. Paul's words, have no laws written out there. God has instilled has written laws in their hearts, and that's what all it takes to be a Christian. So there is a difference, but I don't think that the difference is normatively definitive, in the sense that it may well be that Christian practice is conflict with ordinary laws, and the same questions would have to be raised there. So whether or not it is a source of bias, I think the bias comes from culturally entrenched preference for one's own religion. So the second point, would require, and second and third point would require a lot of words, but I would try to keep it short because I think there are some people who want to ask questions. So, in fact, can I ask you? On the second point, you say, religion cannot be considered as other belief or practices. Is that the point?
Yes, you actually seem to defend strong defense of value of diversity of thought, and you do not distinguish between a diversity of thought of religious thought as opposed to other thought. And it seems to be religion seems to be conceptually distinct, because religion seems to be imperative. At least to some religious laws, most religious laws, they're actually imperative, very much like so-called state laws. That is why the first case of legal pluralism is to point to religious laws, right, rather to other. So I was thinking that you would make this distinction, religion as opposed to other thoughts, other views, other comprehensive views, as opposed to religion.
Well, I'm not quite sure about it. If I understand exactly, and this brings me back to a point I raised before. Well, you know, what I want to defend is the centrality of secular, ordinary laws that are clearly above religious practices, even when religious practices, are or claiming to be imperative. So if there is a conflict between imperative religious norms and legal norms, I am not a legal pluralist in this sense. I acknowledge, however, that this is the core secular dilemma of our societies. It is a core secular dilemma because the state is engaged in freedom of religion, protects freedom of religion as one of the chief values, and yet, in order to define religion or single out religion for special protection, the law has to violate the respect of religious autonomy. So it has to step in the shoes of religion and define it, and define what is important and what is imperative instead of the state. So I think, well, it's a much longer issue, but as far as human rights are concerned, again, it's a very, very broad issue. I would quickly say that, one interesting book to read is Sam Moyn's book. He makes the very provocative claim that human rights are Christian. I don't agree with him, but if you are interested in these issues, I refer to that book, and it's a provocative, interesting claim.
Vincent?
Thank you, sir.
I had one or two, maybe 1.5 thoughts here. And so one, it has to do with, so you said, if I understood you correctly, you said, well, the European communities are too homogeneous and too identified with a particular history and group for this Rawlsian idea of an overlapping consensus to work. So you reject the overlapping consensus grounds on the grounds of, well, the different communities are just too distinct and too homogeneous, and they're not interested in coming to forming an overlapping consensus. And so if that's the case, then the idea of defending religious diversity as a comprehensive doctrine, as a comprehensive value, strikes me as quite puzzling, because then you're asked, that seems even more ambitious than overlapping consensus. Well, actually, because what you're saying there is you can imagine speaking to this community, you say, well, you guys are an insular community, you're a homogenous community, and you don't value diversity. And now I'm going to tell you, you have to value diversity, not because of some allegedly neutral or overlapping consensus basis, but just as some value that I happen to think is important, and I'm going to coerce you into thinking is important. So not only can you, it's different from saying, well, you have to take down the crucifix from your school wall, but you're also going to you're going to keep the crucifix up, and you're also going to put the Star of David and Islamic iconography and a Buddha and this, that, and the other thing, even though you don't value any of that thing, sort of stuff. And so what I'm looking for here is some kind of account of why diversity has this sort of meta-value status that can trump all these other values, why it's not just one comprehensive doctrine among others, in which case it's hard to make an argument for why groups that don't value it to the same degree should have their views discounted. And this, I think, ties into this very interesting discussion that we had earlier about exemptions there, because it seems there, you say, well, I mean, your view on exemptions I find very, very interesting, because you say, well, in a democratic society, you're going to have a majority, the majority religious group will just tend, maybe not out of animus or any particular malintent, but will just naturally tend to pass laws that fit in with its own form of life. And if your view then is a very strict no exemptions policy, you say, well, you know, minority religious groups, we're not going to value any exemptions. That itself seems to be a little bit in tension with this idea of valuing religious diversity as a strong meta value of some sort.
Right. Thank you. Well, let me start by saying that I have to correct the first point. Or perhaps I was unclear in the sense that what I said is that well, European states come from a tradition of deep homogeneity that, to be very clear, goes back to the Treaty of Westphalia. In order to solve the clashes between Christian and Catholic and Protestant, it was necessary to carve out discrete national spaces where the chief religion would be either Protestant or Catholic, and separate nation states along these lines. So that's the root of deep homogeneity of religious practices and values. However, I'm not saying that today European states are homogeneous. So socially speaking, European states are incredibly diverse already, as a matter of fact. So because of immigration, because of secularization that made obviously religion somehow secondary to the secular doctrine. So as a matter of fact, they are very diverse, but the problem with these socially diverse spaces is that they are still somehow under the spell of a deeply unitary ideology that is inherited from the Westphalian Treaty and the Westphalian Pact, and an underlying somehow Christian bias or a set of Christian biases that have not been unraveled yet. So I mentioned radical secularism before in response to then, and I still think that well, that Christian biases are the products of not embraces radical enlightenment. Rather, it was a moderate, watered-down enlightenment that simply stipulated a pact between religious and non-religious people and made Christianity a fundamental source of political and moral values that are sort of written implicitly in every European state. So the account is slightly different. It's not the lack of diversity in social practices, is the presence of implicit biases, inherited biases. And I'm advocating diversity as a value that should be discussed open and loudly in order to tackle those implicit biases that are inherent in European practices. And as I was saying in response to Dan, the value of diversity is precisely to create that space of diversity of thought that has never been, in fact, the paradigm for European practices. So we have never got over the fact that we have practices that are very much steeped in that religious homogeneity. So, and that's the kind of well, that's why I really am in favor of diversity as a meta value, something that can help understanding the psychological even barriers that prevents us from embracing pluralism. And in the crucifix case, well, I'm not only simply advocating that the state should jump in and color the classroom with many different symbols of which nobody cares about. In fact, like my specific solution to the Italian case is not to force either or other option, but to engage the whole population in a new discourse, in a new profound debate about Italian identity, starting with local examples of democracy in classrooms and schools, in local schools, saying, please do not accept that. Perhaps you want to preserve the crucifix in certain communities. Well, but make it a moment of debate about our own, your own identities, and perhaps make it also a critical moment of discussion that can take place all over the country. So, and it's in that sense that, well, I'm again defending diversity, and it's to prompt a deep discussion, debate about our foundational identity that and it's very much high time to engage in.
Thanks. That's all.
Thanks.
Would you pass the microphone down to the corner?
Hello. Very short questions. One is you mentioned that what you're proposing is something about secularism as an ethical program, rather instead of recent challenges to the idea of secularism, of people following the tradition of Talal Asad. One is, I wonder if your term of for your proposal as an ethical secularism, if that does not fall into the same bucket as secularism as another name for another code word for Judeo-Christian arrangement. And then the other one is, because you keep saying that it's not a political kind of secularism, but then at the same time, one of your proposals there also gives a big role to the state to propagate or to promote some kind of diversity. So I'm just wondering, how would you square trying to foster some kind of ethical secularist worldview, but at the same time giving the state such a big role, which I think should be better off, I don't know, trying to imagine it in a way that does not involve the state.
Thank you. Yeah, again, another very, very good question. Am I guilty of the same? Essentially, like just with a different name. I'm aware of Talal Assad's criticism of religion, and I like a lot his work. When I talk about ethical secularism, in my sort of book or longer work, I try to develop a very individualistic ethics, something that would require every individual to inspect his own premises about the belief he holds and the practices that he engages in on those beliefs. I think that it is crucial to stress this kind of individualism, because it's very much the gist, the ultimate position of my work, in the sense that I wouldn't want in an ideal society, everyone would be self-reflective and fully reflective about one's own beliefs, and would be entitled to all the whatever belief he has, and still be capable of living together meaningfully with other people. Unfortunately, the problem is that we, in any country, live with the fact that certain beliefs tend to group people to act in a certain way, in a way that is potentially undermining of the authority of the state as an institution. So that is that is where I have to sort of fall back in more conventional sort of accounts, in the sense that perhaps I would advocate the importance of individuals to engage in that route, but I know that it's not something that everyone would do, and so the state has to have some instruments, as I said, in order to regulate what kind of religious practices are acceptable and what kind of religious practices are not acceptable, and that's perhaps the element that is more similar to the orthodox liberal or political views. I do not deny that, but it is only used in instrumental terms.
Okay. Craig, could you pass that microphone to your left?
So my question's been swirling around. Hopefully something coherent remains. It comes back to this overlapping consensus, and it was sort of a throwaway, I don't know if it was a throwaway, but it was just one remark in a long presentation. But of course, Rawls, I know something about that, and so everyone's going to want to talk about that. But maybe there is something to do with this. I'm not sure your argument, I didn't hear a criticism of this idea of overlapping consensus in your argument, though maybe I heard, and in fact, maybe you might be using something very much like the model of overlapping consensus. As I understand overlapping consensus, a couple of key elements are the point of overlapping consensus, in part, is to provide a principled stability for a society. And so one thought I had was that, well, maybe your thought isn't, it's that you're criticizing or rejecting Taylor's or Rawls's account of the basis of the content of the overlapping consensus, or perhaps the basis of the overlapping consensus, as opposed to rejecting the model of the overlapping consensus. And the reason why I thought you might be using the model of the overlapping consensus is because you have this idea, you said a couple of times how, you said something like negative secularism doesn't give us any reason or motivation to sustain, some sort of, I guess, practice of freedom of religion or something like that, I take it. So one thought might be is that, look, one question is, I'm not sure what level, if you use this model, you want to place negative secularism and your ethical secularism, if it goes at the bottom or if it goes at the level of the overlapping consensus. And then then another question would be, aren't you telling a kind of overlapping consensus story? The thought is that there are seeds in Europe, the possibility of valuing diversity for its own sake, and that value is widely shared and could be a key ingredient in sustaining an overlapping consensus. But there's nothing else that would really be able to do that role systemically in Europe.
Well, thank you very much, Stefan. I was way too cursory and quick in this presentation. Part of it is because sometimes this kind of debate takes the lion's share, and I wanted to focus on something else. But you're right. It is something very important to discuss also, because it is central in Taylor's account of political secularism, and let's put it this way. You know, well, it's not as if I dismiss the overlapping consensus altogether. The points I'm trying to make is that, well, Rawls or Taylor or Habermas, well, accounts of the place of secularism are missing out something fundamental, well, a fundamental stage that they are not capable of addressing. That is the fact that before you can even start talking about overlapping consensus, you have to have an understanding of the political emotions that populate the communities in given context. And in order to prepare the ground for a possible overlapping consensus, what I'm saying is that one needs to do a whole, one has to engage in a whole exercise of clearing the ground from those negative emotions that prevent the formation of genuine overlapping consensus. And what I'm referring to, and if you want to take an example close to Dan again, you know, it's impossible, you know, in a place like Israel to reach a reasonable consensus, an overlapping consensus between people on what to do between Israeli Palestinians, because, well, because the emotional obstacles, the emotional superstructures that have been that are lying there are way too big to allow for any philosophical exercise to take place. So I'm advocating, and I do more at length in other paper, the necessity of engaging in a mental health or a more psychological groundwork before you could even start to talk about reaching an overlapping consensus. So ideally, yes, I would want to use that. I would love to be able to pinpoint to that. But what I find is that it's impossible without that groundwork of unearthing the biases that are very much present in the societal context that I know. So, you know, the first stage is about understanding, unearthing those political emotions, and only then, perhaps, reconstruct on that basis. Sorry, is that?
Yes. So Lorenzo, if one of the main goals of your projects is to find an account of secularism that can generate those positive political emotion, and there's really a deep psychological component to what you're trying to achieve, I was a bit puzzled by how you started your presentation by saying, you know, there were those terrorist attacks in France. One of the main root is obviously economic, and then you confessed your Marxist sympathies. And he said, well, yeah, but that's obviously not all. There are also these negative views of secularism that generate a form of alienation, right? Now, if you're a true Marxist, you would say, well, obviously that second part goes, right? Religion is the opium of the people. The real issue is economic. But I was puzzled by the fact that this simply dropped out of the picture, right? That's a pretty bold claim, right? You're saying, yes, I'm a Marxist in some ways, and this has something clearly to do with it, but yet I'm going to focus on secularism. If the goal is to say what can generate positive political emotion, then it seems to me that you can't avoid at some point in the argument trying to disentangle those two, right? Because one argument might be that, you know, it's true, economics drives people's emotions on that case, right? So when things go badly, you look for a culprit. Of course, when you're at the beginning of the state-building process, you know, it's India, we're kicking out the British, let's all live together, right? We don't want a communal India, we want an India where the Muslims, Hindus, and everything live together. It's wonderful. It's wonderful in Canada when we're doing so well economically to praise diversity so highly. But when things start going a bit rougher, right? We've seen this in India, suddenly Muslims are a problem. They make too many babies, they don't work. And in certain provinces of Canada, which are benefiting from our federal regime, yet might not be economically as vibrant like Quebec, nationalism has taken a very if you want, religious tangent that is akin to the French model, right? So I'm just wondering whether diversity is not too diffuse and the considerations are not, if really the goal is to say where can we find those positive political emotions, that's really a tangent to what's going on. Right, so that's kind of a meta argument for, or a meta consideration for you, but you kind of opened yourself up to it by mentioning Marxism initially.
Yes, well, no, it's very good points, and yes, and again, I haven't really developed that very much in depth. The Marxist though has a connection with the more radical secularism I defend. It has a connection in the sense that I interpret Marx as advocating the priority of desires that are embedded in economic structures. Alienation becomes when the real desires of people are not met by any of the social structures in the society, and this emotional basis is very important also in the sense that when modern European secularism started to become popular in Europe, it somehow cut the link between the narratives that were used by the community at large to construe their positive political emotions, Christian narratives, really, and the people. So what I'm trying to demonstrate here, and I guess it would require, it does require much longer account, is that ultimately the problem with negative secularism is precisely that it ends up alienating people in the same sense, deep sense that Marx is advocating. So it cuts it does cut the root of political narratives from the basic desires that the people have. And if anything, this account as parallel in what I mentioned before as radical enlightenment, because I believe that Marx, in fact, develops his theory of alienation on the background of Spinoza's ethical theory, but somehow he subverts or misunderstands Spinoza to the extent that he would want, and that's where I depart from Marx, because I think that he wants to explain everything in terms of material elements and completely remove the normative side from the account of political society. I think that the normative side cannot be removed so clearly. It cannot be removed at all. In fact, where Marx is going wrong is precisely it's precisely when he drops altogether the normative language and the language of of ethics in relation, as an expression or as a way of cultivating and correcting human desires, as a way of orientating human desires towards the projects that are really making people flourish. So there is a deep connection between Spinoza and Marx, to conclude, but and it's about alienation, but Marx gets Spinoza wrong, and that's where I also depart from Marx, and that's why I sort of miss his influence in the picture. I think that Marx is wrong in not articulating a proper ethics.
Okay, we're going to take one more question. I'm going to have to apologize to those who want to get a second question in, but we've got one more question. Will.
Thank you very much. It's been a really, really interesting talk and discussion. I'm still having difficulty grasping what you're asking for, and maybe we can focus on it by focusing on your idea your picture of reimagining what a classroom would look like. You said you don't want necessary, right? So given the biases toward the Judeo-Christian point of view that you claim exist in Europe right now in the laws and practices and so on and so forth, I take it you want the removal of crucifixes from classrooms. Is that right?
Well,
because that supports and feeds and is a reflection of the bias.
It's in the end, I would very much advocate that. But but it's very important the process through which you refurbish the room, refurbish the classroom. So I'm saying that it's not quite as easy as let's just get rid of it and everyone will be happy. It's but ultimately, as a first step, I would be happy to remove the crucifix.
Okay, then suppose that step, together with a whole bunch of other steps that are taken, result in removal of the bias. Okay, and so you no longer have the Judeo-Christian bias that you see reflected in laws and practices and so on and so forth. Would you then be willing to reintroduce crucifixes into the classroom if that were, say, acceptable to the community in question? And if you were, then I guess my worry then would be that it's in the nature of religion that it will close off the kind of diversity of thought that you want, because religion tends to be, I think this came out in one of the earlier questions, it tends to issue categorical demands, relatively immune from ordinary standards of rational critique and so on and so forth. And so there would be a tendency, if you let religion back into the classroom in any form, even with the biases gone, that the biases would reemerge. So I wonder whether you would, in the end, be forced to say that under all but very unusual circumstances, all religious symbols ought to be removed from the public space.
Right. Yes. No, that's a very, very interesting question. And I really like that. Well, you put it in the context of this case, because I'm very attached to this example in many ways. First of all, because I was exposed to it as a child and as a teenager, And secondly, because, well, perhaps the more important intrusion is the fact that we still have a class in religious education taught by the Catholic Church, although it is optional. But this is just my personal background. What I'm trying to get at here is that the very nature of education in Italy but in any other states is to be rethought. So perhaps the issue of religious symbols is actually a very good pretext to start a much deeper thinking about the nature of education in public schools. And one of the tasks and goals of education in public schools would be to promote the kind of value of diversity that I try to defend. And in order to do so, it's not simply enough to, well, remove a crucifix. That would not remove the bias. So
everything else that goes along with that.
Yeah, well, it is a symbol, obviously, but that's why it is a good starting point. Actually, you could say that there is something to celebrate in the fact that, well, a patent injustice is still symbolically present in the classroom because it could give a fantastic occasion to rethink fundamentally the way in which children are educated, the way in which the school pass on a certain type of information. I'm very much in favor of a type of education that perhaps is considered to be alternative, say Montessori or even a more somehow liberating type of education that is very much invested in the quest of psychological freedom for the children in the children development. And I think that the way in which education works right now is simply inculcating a certain set of pre-cooked values that are very much part of the sort of liberal or overlapping consensus type of agenda that has never been discussed, but has always been accepted as a sort of a prepackaged liberal Christian type of set of values. I do think that we in Italy had a perfect chance to engage in that debate at the local and national level. What I deeply resented in the decision of the European Court of Human Rights is that it never even solicited a better thinking on the part of Italy. The presence of the crucifix is justified by a royal decree of 1929 taken by Benito Mussolini in relation with the Catholic Church, a very relatively minor administrative decree that describes the furniture of the room. And the fact that we just take it for granted is a source of shame. So, I would have loved, and that's what I advocated, I would have loved Italy to engage openly in saying, well, what kind of society and state do we want? And more importantly, what kind of education do we want for our children? What kind of space do we want our children to grow up? And what kind of psychological biases do we want to inculcate in them. And obviously we haven't done it, and we have lost a great occasion. So I don't know if this clarifies what I'm really trying to get at. Perhaps it is asking too much from a legal case. Perhaps it's something much broader, but I used these cases as a springboard for a complete rethinking of our premises about secularism.
Okay, well, I'd like to thank everyone for your questions. Please join me in thanking Professor Zucca for an excellent discussion.
Thank you very much.